Good morning, everybody. It's 10 o'clock, so we're at the start of the Countryside Rights of Way panel for the Friday the 13th. So hopefully everyone's got here safely without any problems. Could we start with apologies, please?
Yes, Chair. We've had apologies from Councillor Abrahams, Councillor Waring and Councillor Williams.
Thank you. Could you supply with me with a list of who's been and who hasn't been today and who's apologised? Yes. Thank you. Item number 2 is declarations of interest. Has anyone got any? Nope. Okay. And moving on to item number 3. Now we've got a slight additional item here. The meetings of the 9th of August were signed off, but I think there's been a need to amend them slightly, so I'll hand over to Simon.
Yes, thank you, Chair. So, morning everybody. Just for members' attention, the meeting that took place on the 9th of August, the minutes for that particular meeting were brought to you at the meeting that was held on the 16th of August for your approval. Unfortunately, due to a bit of overlapping of annual leave, there were some items missed from the minutes, and I'll go through them for openness and transparency with you so you can know exactly where those changes have been made. Just for clarity, the discussions did take place, the decisions were made, so we're not adding anything else. It was just something that was omitted from the minute. So paragraph 3 of item 6, which relates to the application to add a restricted byway from Weeks Barn to Slade House. Originally, it stated that the panel had decided that available evidence submitted by the applicant and that discovered by the County Council was sufficient to show that restricted byway subsists along the route marked A to B and B to C. Unfortunately, we'd missed out and C to D. So that has now been added back in. That has resulted in the decision A being changed to also add in and C to D. We've also added in a little bit, and a change to resolution D, where it said, let me just, it mentioned that the order should be made to upgrade part of the public bridleway 10, going into a restricted byway marked A to B. That has now been changed to C to D. Hopefully this is clear for everybody. Item decision D, that an order should be made to upgrade part of public bridleway 10. Sorry, I've just read that out. I do apologise. I'm reading somebody else's notes, so I'm very, very sorry. We've also added in at decision E that the width of the route will be 3 metres throughout its length. That was omitted from the original minutes. I'm hoping that's clear. I'm sorry if you would like me to go through that again, because I think I may have repeated myself. Does that make sense to members?
Yeah, we're all there, weren't we? So it was quite complicated on the day. So
I move the amended minutes, Chair.
you certainly can. Do you want to second them, Carolyn? Yes, yeah. Okay, all agreed then.
There we go. Sorry. Thank you.
I'll just sign them, and then at least we know that we've done that bit. We've dealt with that item number 3, and item number 4 is the minutes of the meeting held on the 16th of August 2024. Has everyone had sight of them? Yes. Are we happy with them?
Yeah, move the chair.
Okay, thank you. Right, item number 5, delegated decisions. It does say here, that there are no decisions that have been determined with delegated powers on this occasion, as set out in the Countryside Council's scheme of delegation. This item of delegated decisions was put in by, or pushed for, by David Smith. Are you happy that we're doing that? Thank you. And item number 6, please, which is Wildlife and Countryside Act 1981, the application for the upgrade of public footpath 17, brackets parts, Warslow and Elkstones, to a public bridleway and the addition of a public bridleway either side from Stonyfold Lane. Who's taking this? Thank you.
Thank you, Mr. Chairman, members of the panel. And again, I can confirm that we've had no objections or representations from the local member. This is an application for the addition of a public bridleway in the parish of Warslow and Elkstones in the district of Staffordshire Moorlands. I'll move straight to the recommendation in that the evidence is not sufficient to say that the route subsists either on the balance of probabilities or indeed on reasonable allegation. This has been one of the most intriguing matters your officers have dealt with to date, and one which has relied heavily on the interpretation of the evidence before us. It is an interesting application consisting of a continuous route made up of an upgrade and 2 additions. The upgrade relating to a short section or part section of public footpath 17 Warslow, and the additions then connecting this part section to the highway at either end. Members will see the line of the route on the plan attached to Appendix B of the report with 3 distinct sections labelled A to B and C to D for the additions and B to C for the upgrade. The section B to C that runs approximately east to west is the current line of public footpath 17, and this is highlighted green on the plan. The additions either side are highlighted in orange. But what evidence do we have to support the application? Clearly, for the whole route to succeed, then the upgrade, at least, will need to satisfy the higher test of the balance of probabilities. As such, the evidence will need to be good. If not, then the entire claim could fail. In this matter, we have evidence submitted by the applicant and we have evidence discovered by your officers. All of it is historical and all has been evaluated very carefully to arrive at this conclusion. Turning to the application evidence, we find an extract of the Alstonfield Enclosure Award and map dated 1839, a survey of Warslow dated 1841, an Ordnance Survey map dated 1842, and what appears to be a contemporary photograph in colour of the alleged route, all submitted by the applicant. Of all this evidence, the Enclosure Award is pivotal. It is the only evidence posited that is of sufficient probity to satisfy the higher test of the balance of probability, that is, the upgrade of part of public footpath 17 Warslow. As members will know, Enclosure Award evidence can be conclusive in its own right, and as other evidence is limited in the application, it is on this that the matter will largely rest. Turning to the relevant extract, we can see that it refers to the route in question together with 2 other unrelated routes, all of which are visible on the plan. The excerpt for the alleged route is a brief but detailed paragraph annotated in the normal way in the left-hand column of the sheet, the indented heading reading Whitefield Gate Road, 18 feet wide, map 4. It is interesting to note that the route is allocated a set name, and while this could be suggestive of a public way, it is by no means conclusive. Private routes could also be named in a similar fashion. More important is a description of the text and whether there are any express references to it being either a private or a public route. Clearly, this was not discernible in the somewhat limited extract submitted by the applicant, and so officers were compelled to examine the full extent of the award and plan. The route was referred to in closure as one other carriage and drift road in the township of Lower Elkston to be called the Whitefield Gate Road and to be of the width of 18 feet. Pulling this statement apart somewhat, it reveals firstly that the route was both a carriage and drift road. These often appear together in old awards, and while a carriage road can be either private or public, a drift road leans more towards a private route. Drift roads were largely used by local farmers to drive stock from field to field, and while not necessarily fatal to the claim, the presence of a drift road does nothing to support it. The description of the route branching out of the Lower Elkstone and along the road is also somewhat misleading. It could be interpreted that the route is therefore public, as it joins a public highway, although this is not necessarily the case. Private routes can also connect to public ones, as clearly neither can exist in isolation. More convincingly, perhaps, is the fact that the route is coloured in the same way as the other known public highways, and at first glance this would seem to ebb tentatively in its favour. Until, that is, we know that the private routes are also shown the same. Averill Lane, for example, is also coloured pink. Turning to the statement, we find that the Commissioners had set out the route known as Whitefield Gate Road for the use of all persons who require, think proper, or have occasion to use the same. Taking the first element of this statement, the use of all persons, does of course imply that the route was possibly a public one. However, if this was the case, why would the Commissioners need to stipulate such a provision at all? A public route was for the use of everyone, and the wording imposes what is effectively a limitation. Although it appears to be fully inclusive at first glance, its use is nonetheless restrictive. It was for the use of all persons who, as opposed to all persons, without further stipulation. As such, we find all persons who require, think proper, or have occasion to use the same. In other words, all persons does not actually mean all persons. We could quantify this further by suggesting that to require suggests a need or obligation, to think proper suggests there is a set reason, and to have occasion could imply necessity. I am sure that other interpretations can be ascribed to these stipulations, and the very fact that we are trying to interpret them highlights further that the route was not set out without condition. And a public route, of course, would have been. The award also confirms the use of the route by those whose lands adjoin the same, effectively including these specific users as well as the other groups referred to above. And again, this would be unnecessary if the route were truly public. The overriding fact is that a stipulation is made, and this by its nature is a limitation to its use. Turning to the maintenance of the route, we find the Commissioners had set it out to the several owners and occupiers for the time being of the lands and hereditaments within the said township of Lower Elkstone by a general rate of assessment according to the value thereof respectively. If the route had been intended to be public, then the maintenance would have likely been vested in the whole parish rather than just a section of the parish, in this case the township. As such, it appears that the award set out the maintenance to a few people within the nearest vicinity of the route and not the parish at large. So far, we have nothing conclusive to determine whether the route was public or private. However, this position quickly falls away when we turn to consider the width. Whitefield Gate Road was, as members will recall, set out to a width of 18 feet, and although this is slightly wider than the private routes at 15 feet, it is still well below the legal standard required at the time. After the General Enclosure Act of 1801, widths for public carriage roads were standardised to a minimum of 30 feet. As such, the Commissioners of 1839 would have been acting ultra vires if they had set out a public road to the width of 18 feet. However, local variation did occur, and as such, it was necessary for your officers to assess the full context of the award. This revealed immediately that the route was almost certainly private rather than public. Critically, the public carriage roads were clearly identified under a separate section headed Public Routes, specifying their correct minimum width of 30 feet. The apparent non-public routes, including Whitefield Gate Road, were set out to varying widths, all of them being under 30 feet. For clarity, Whitefield Gate Road was not listed among the public carriage roads, but was instead to be found among the private routes, clearly denoted by its width and maintenance responsibility. In addition, the enclosure plan reveals that there was a line across the alleged route. This can be seen approximately halfway along its length between plot 12 and the old enclosures, and most likely indicated a gate or other obstruction. Again, although a gate could exist across a public route, it is much more likely than not that when combined with the inferior width, the route was private. Turning to the other evidence submitted by the applicant, we find a survey plan of Worslow and Elkstone dated 1841. This shows the route to be unnumbered and is the rest of the public highway. However, being a document of limited probity, nothing significant can be gleaned from it. In fact, both the enclosure plan and the survey plan suggest the route was somewhat vague in places. The demarcation is faint and broken at certain points along its length, avering against a well-defined route upon the ground. A public carriage road would have been expected to accommodate a full range of horse-drawn vehicles. As such, the 1841 survey mirrors the enclosure plan and then presents us with features such as gates and ill-defined bounds, which all support our growing contention that the route was, and indeed is, private. Turning to the photographic evidence, we have a colour picture of the alleged route, which appears to show one section of it. Although it's always interesting to see the routes we talk about, it has little legal bearing on the matter. This is an application based on historical or documentary evidence, and the presence, or not, of the route is of little or no concern to us. Lastly, we come to the Ordnance Survey Plan of 1842, which of course is near contemporary with the Enclosure Plan of 1839 and the Survey Plan of 1841. As can be seen, the route was clearly significant enough to be recorded on the OS plan, as if it was in the other documents we have seen. However, as members will be aware, Ordnance Survey evidence is never a record of status. It merely records the physical feature on the ground. For further clarity, officers checked Yates's map of 1775, which is one of the best, if not the best, large-scale maps of Staffordshire, and officers were only able to discern a small section of the lower end of the route, and even this was by no means clear. Officers were also able to obtain the sale catalogue for the Harper Crew North Staffordshire estate, dated 1951. These colour plans were produced by W.S. Bagshaw and Sons, surveyors of Uttoxeter and Ashbourne, and give some insight into what was perceived to exist at the time. Plan number 5 shows the application route, and although the southern section is present, the northern section is by no means clear. The line of public footpath 17 Worslow can be clearly seen marked with the letters FP, but the line of the northern half of the alleged route is virtually missing. The plan does, however, confirm that there was nothing to indicate a public carriage road on the ground in 1951, which of course supports what we know about the route. Turning to the landowner responses, we find that there was one primary landowner who objected to the application, stating that the said path is not and has never been a bridleway. He goes on to say that the route was an agricultural access lane and the only known right-of-way is public footpath number 17. The landowner goes on to highlight a number of concerns he has about the claim route relating to health and safety and security, points echoed by the local member. However, the panel will know that we cannot consider these concerns under the law as it currently stands. Notwithstanding, it is somewhat immaterial in the instant matter, as all the evidence points to the route as being private. Following the circulation of the draft report, the applicant submitted one of the best counters your officers have seen, and members will find this in the addendum of the report. It might be useful if members could now turn to this, as it deserves some consideration, and we should evaluate the points raised. So you should have a list before you with a top sheet giving 4 appendices. In summary, these counters relate to your officer's interpretation of the enclosure award, additional evidence from the Finance Act, queries about the 1949 survey, and a selection of county and other maps. All good and worthy points. However, officers have considered them in detail and can only maintain the following stand, and I will address the key points in bullet form. Firstly, the maintenance liabilities found in enclosure awards can be somewhat complex, and non-public or private routes may indeed have differing maintenance liabilities. However, we would need evidence for this, as given in the Brampton example posited by the applicant. As you will see, heavy public use is cited, and eventual maintenance by the surveyor of highways is clearly visible. We don't have this with the claim route. Next, the Wetton and Alstonfield Road is cited as an example of a public road with an inferior width. It does, however, record a default width of 30 feet along its length, which the claim route does not. As such, we have at least part of that width set out to 30 feet, indicating that this was indeed a public carriage road. Again, in the instant matter, we do not. Next, it is agreed in common ground that the alleged route is not set out as a private carriage road, although the other 2 carriage roads in the same section are indisputably private. Again, officers can only reiterate that each has to be considered on its own merit. Next, of the 39 non-public carriage roads in the award, it is agreed that 24 are clearly private at a width of 15 feet. The remaining 15 routes are mainly 18 feet in width, and despite the fact that they may now be public routes, and some with metal surfaces, each will have been decided upon on its own merit. It is impossible to say how these routes became public, and it may have been through a variety of different ways. The bridleways and footpaths in particular could have been claimed by user, at the time of the first draft map, or even later. As such, we cannot ascribe a status to a route by proxy. Next, the maintenance liability of Whitefield Gate Road is granted to the owners and occupiers of the township of Lower Elkstone. However, this refers to a limited number of people in the township of Lower Elkstone rather than the parish at large, and no reference is made to any future involvement of the Surveyor of Highways, as is seen with the Brampton example referred to earlier. Next, officers uphold that the stipulations of use constitute a limitation and so aver against a public status. Next, turning to the positive maps on the 1910 Finance Act plan, only the southern end of the route is shown as separate from the taxable holdings. Officers agree that this section likely depicts a road or track, but also suggest that this could still relate merely to a private route, as the applicant herself attests. As such, nothing turns on it. Next, potential omissions by the parish survey of other routes in the area are largely conjecture and open to interpretation. This goes for the surveyor's letter as well. Next, the aerial photograph and map that references physical features and furniture on the ground is open to debate. Indeed, any reference to the current position on the ground would be irrelevant to an historical application resting on evidence from 1839. Next, the Harper Crew estate map of 1886 does, as officers agree, show the feature of the route, but it adds nothing of probity to the claim. This is an estate plan rather than a sale plan, and as such has limited legal weight. Next, Yates's map of 1775 has large sections of the route missing, where it allegedly passes through common land. This may be the case. However, the fact remains that sections of the route are missing, and even if this was not a county map, it has very little probity. It shows primarily the physical feature, is too large scale to offer accuracy, and could potentially relate to a private route. Next, Greenwood's map of 1819 is better and shows the route in full. However, it is again a county map and has somewhat limited probity where status is concerned. Finally, the 1837 OS drawings appear to show the route, but again they are silent on status. As such, despite presenting us with an excellent counter, nothing turns on any point, and officers can only maintain the said position. In summation, there appears to be no evidence to support the contention that a public carriage road was set out at the time of enclosure, and nothing to support the existence of a public bridleway or public carriage road beyond this time. For clarity, there is no evidence of a public bridleway, or indeed a private bridleway, being set out or referred to anywhere in the evidence. The enclosure award indicates that Whitefield Gate Road was set out as a private carriage road, and that the middle section, which is the subject of the upgrade, has only ever been a public footpath. As such, your officers can only recommend that the application be rejected and that an order should not be made to add the route to the definitive map and statement of public rights-of-way for the district of Staffordshire Moorlands. Thank you, Mr. Chairman, and I'm more than happy to run through any of it again, or of course to take any questions.
Thank you very much for an extensive and detailed presentation. Could I just, before we go on to questions, page 61, just to clarify, Councillor Jill Heath has sent a letter in, and she does say, I'm sending the paper trail below on the letter from, that's redacted, to dispute the wrongful claim for a bridle path. I think we can take that as she's against the application. David.
Thank you, Chairman. Could I just clarify a couple of points? I note all the arguments about this being private and whatever. I was interested to know whether this, although it's not a recognised footpath, whether it was in current use by the public, or whether it was just simply a historic access that people had used that had no status. We get a lot of these applications that come to this committee which are dealing with footpaths, either formal footpaths or non-formal ones, that are simply being brought to us because they exist on a map but have long since ceased to be used. So I wondered whether this, although not a public footpath, whether it was in regular use. And the second thing I was going to ask about, I don't think in my quite long time serving on this committee that I've ever heard a reference to a drift road. And I understand from what you were saying that a drift road is simply a route by which cattle and livestock are moved from field to field, and it has no status whatsoever. But I just wonder whether you could fill us in on that. Thank you, Chairman.
Thank you, Mr. Chairman. To take the first question over the current use of the route, officers have no knowledge about whether that is continuing to this day or not. We believe that the route is no longer accessible. We believe it's a private area, and this is based purely on historical evidence. So often the physical feature on the ground is just not there. We're looking at information, documentation from the early 1800s, and to our knowledge, no one's come forward to say that it's currently being used. To refer to the point on the drift road, the drift roads are commonly seen in historical documentation, and they are just simply agricultural tracks or lanes that cattle would be moved across from and transferred from field to field. So they are more and lean more towards a private route than a public route. In most cases. However, every rule has an exception. In this particular case, the drift road, as referred to, is clearly a private route. Thank you.
Just to add a little bit of extra on that one, drift roads historically for farming, and obviously I'm a farmer, were the only way that people could get their stock to market. In fact, they actually sometimes went vast distances across the country to take them directly into London and such like. So when you see freedom of the borough to bring your sheep down, that's connected with the drift roads. So and that, by its very basis, sort of proves it's a private function. Caroline, do you want to speak?
Actually, David has asked my one and only question, which was the user evidence. But I'd just like to thank you for such a detailed report, and I have the greatest respect for Councillor Jill Heath, and she knows her area upside down, back to front, and yeah, her report in there saying that this isn't a public right of way and never has been used, so is good evidence as well, surprisingly, her being in that area for so long. So I just wanted to say I want to accept this as officer's recommendation. No more work could have been done to this. It's an absolutely excellent report, and I back it 100%.
Got a proposal? Seconder? I agree. So we'll go with the officer's report. Thank you so much. And we'll move on, please, to item number 7, which is an application for the upgrade of PF8 water houses to a public bridleway. And are you taking this? Thank you.
Yes, Chair. Good morning, Mr. Chairman and members. May I start with confirming that we have not received any representations or objections from the local member. The recommendation is also to reject the application. This is an application made under Section 53 of the Wildlife and Countryside Act 1981 for an upgrade to public footpath number 8 Waterhouses to a restricted byway. The application was made on 2nd of June 2019 by Louise Redfern on behalf of the Staffordshire Moorlands Bridleway Group. Her evidence included an extract of the first definitive map, a copy of Ordnance Survey First Series Plan dated 1856, a copy of the Finance Act 1910, a copy of Carlton Township Tithe Map for Mayfield Parish, and a copy of Carlton Township Tithe Map for Waterfall Parish. The applicant also provided a copy of the Waterhouses Parish Survey Card for Public Footpath 8, completed 7th of April 1952, together with its accompanying plan and a copy of the statement accompanying the draft map. In addition to this, members may recall that at panel on the 19th of April 2024, they considered an application for the upgrade of a footpath to a restricted byway for public footpath 10, Waterhouses Parish. Waterhouses 10 recommendation was to upgrade the route, which members accepted. The application, which was considered in April, adjoins the route of the current application. Documentation that directly related to Waterhouses 10 was also considered in the current application. This included a copy of Carlton Tithe Map for Blaw Parish, an extract from OS Map Dovedale and Tissington and Key, and Bartholomew's Plan and Key dated 1902. This evidence also included an Ordnance Survey Map 14.6, 1881, an email from the National Library of Scotland dated 20th of April 2017 regarding shading of roads on Ordnance Survey plans, and Greenwood's Map of Staffordshire. Further evidence has been received from Julie Turner on behalf of Staffordshire Moorlands Bridleway Group, which can be found in the addendum. It has been considered by officers, but it did not change officers' recommendation. There are no comments from officers within the addendum as a result of the further evidence and comments having been received following the initial consultation deadline. Should officers' recommendations be accepted, however, and a Schedule 14 appeal submitted to the Planning Inspectorate, the further evidence and comments will be included at the appeal stage. The tithe maps of both Waterfall and Mayfield Parish were considered. The route is shown as a physical feature on the ground being separate from adjacent landholdings. Both tithe map plans show a route linking Farwell Lane to the east and Waterhouses Public Footpath 10 to the west. The tithe map for Blaw was also considered. This plan for Blaw does not show the route, despite showing the surrounding routes and fields. This may, however, have been because the tithes draftsman did not feel the need to include it, as the route had no effect on the tithable value of the land. The Finance Act plan is depicted with continuous solid lines either side of the route, suggesting that it is a public highway, which would, in many cases, although not necessarily, be a vehicular highway. The route is currently a public highway because it is recorded as a public footpath. In the absence of the field book, however, the plan only shows a physical feature on the ground. The parish survey card, plan and statement are the only evidence that this route has been used as a bridleway, and this is clearly shown. The route was shown to be a RUP, a road used as a public path, while the accompanying survey plan showed it to be a cart road used predominantly as a bridleway. The parish survey cards, however, are only supportive evidence, and whilst this would most likely be sufficient evidence to accept the route based on reasonable allegation, because this is an upgrade, our evidence burden and standard of proof requires us to consider the route on the balance of probabilities. The Ordnance Survey Plan revised in 1979 reflects the route as one used as a public path in accordance with the County Council's Parish Survey Plan some 25 years earlier and prior to any general or special review by the County Council. The Ordnance Survey Plan of 1856 and the Ordnance Survey Plan 14.6 published in 1881 also shows a physical feature on the ground between what is currently public footpath 10 and Farwell Lane. On the 1881 Ordnance Survey Plan, the route is not coloured with sienna, unlike footpath 10 and Farwell Lane, but is labelled parcel number 22. Unfortunately, there is no field book that can identify this parcel number to establish its status. The email from the National Library of Scotland states that prior to 1896, all roads were the same class, but instructions for shading a road were as follows. All metalled public roads for wheel traffic kept in good repair by Highway Authority will in future be shaded. The source, Oliver et al., 2005. This lack of shading is suggestive of the route having been considered to be a footpath or a bridleway, but there is nothing to suggest which. In the absence of any further evidence, it has to remain a footpath. Neither Greenwood's map shows the route or any physical evidence of the route, and nor does Bartholomew's map. The majority of the documentary evidence show the existence of a separate route from adjoining landholdings. However, with the exception of the parish survey documentation, which does refer to the route having been a bridleway, there is no other supportive evidence of these higher rights. The report was sent out for initial consultation on 7th of August 2024, and there has not been any response to the initial consultation from either landowners, statutory consultees or user groups, other than Staffordshire Moorlands Bridleway Group, who have supplied further evidence. There is just one legal test which must be satisfied before a modification order can be made for the route, the test being whether on the balance of probabilities the higher rights subsist. It is your officer's opinion that the application for the upgrade between points A to B on the plan attached to the report does not pass the balance of probabilities test under section 53(3)(c)(2) of the Wildlife and Countryside Act 1981. Thank you, Mr. Chairman. I'm happy to take any questions.
David.
Chairman, could I just ask the same question that I asked previously? Do we have evidence that this is currently in usage, regardless of whether it's legal or not, or whether it's just simply an overgrown one that somebody's dug up some evidence on?
Yes, Councillor Smith. The applicant does actually say that she uses the route currently on horseback, and she has explained that there are gates at either end, and although I cannot say for sure how much use or no use is made of it, it does appear to be a through route, and I suspect that people are currently using it as it is a public footpath at the moment. So I don't know how well used it is, but it is labelled as a public footpath and maintained by the County Council. I hope that answers your question.
I mean, we get so many that come here that are and have not been used for a very, very long time. I mean, presumably, although it's not recognised as a public footpath, if people are using it, there's no objection by the landowner, that's of no concern to us. And so, on that basis, Chairman, I'd be happy to move recommendations 1 and 2. Thank you.
Yeah, thank you, Dave. So we've got a recommendation that we go with officers.
I'll second that.
Okay. So I'll agree, obviously, as well. So that item goes along with the officer's recommendation. Thank you so much for your time and putting into that. We'll move now, please, on to item number 8, which is the Wildlife and Countryside Act 1981 application for the addition of a public footpath from Gamesley Bridge on the A5 405 to the A5013 opposite Worston Mill Lane, Stafford. Now, the local member for this is Jeremy Pert. It's right next to my division, and I do actually take grain into the farm that is obviously where the footpath route has been proposed. So I'm going to sort of first of all put a personal interest in, please, and secondly, David, would you take this item? Yeah, so as I say, I'm putting a personal one in, so I can vote at the end, but I think it'd be wrong for me to chair it.
Thank you, Chair, members. This is an application for the addition of the alleged public footpath from Gamesley Bridge on the B5 405 to the A5013 opposite Worston Lane. The application is supported by historical evidence. The application route can be seen marked A to B and B to C on the plan attached to Appendix B. The local member has confirmed that they have nothing to add to the officer's recommendation and has no knowledge to assist the committee with their deliberations. Turning to the evidence, officers have considered the Drayton Junction Deposited Railway Plan, dated 1863, the Finance Act Plan, dated 1910, the Parish Survey Details of 1954, and the Ordnance Survey Maps, dated 1879 to 1954. On analysis of the Deposited Railway Plan and Book of Reference, whilst this appears to show a short section of the alleged route, it is important to note that we cannot clearly determine the line of the route of where this begins and ends from this evidence. The record book accompanying the Deposited Railway Plan refers to a bridleway in connection with the route in Plot 6 of the plan. This portion could be said to correspond to a section of the route marked B to C on the attached plan at Appendix B. An interest in that plot of land is listed as being vested in the Surveyor of Highways, which is suggestive of this portion of the route being public. However, the deposited railway plan does not provide a full depiction of the line of the route between A to B or B to C, and as such, the full extent of the route cannot be determined. Moving to the Finance Act plan, the section of the route marked B to C does not appear to be in plot number 939 at all. The section from A to B would appear to be recorded in the plan and is noted in the accompanying valuation book as an alleged footpath. It is worth noting that deposited railway plan does not depict any portion of the line marked A to B of the claimed route. This means that the Finance Act plan alone, with the only reference made to the route marked A to B being alleged, does not provide sufficient evidence to support the existence of a public highway along the claimed route. This means that the section between A to B is only recorded on the Finance Act plan, and here it is shown merely as an alleged route. Clearly its status was unclear in 1910, and as these plans typically show both private and public routes, there is an equal chance, based purely on this evidence, that the route was actually private, and as such the Finance Act adds nothing to the application. Whilst the claim route is visible on the Ordnance Survey maps, these maps do not provide any evidence as to the nature or legal status of the routes depicted. In fact, the only evidence gleaned in relation to the status of the claimed route marked A to B is the mention of an alleged route on the Finance Act map plan. This alleged status alone does not offer sufficient proof to confirm that a public footpath existed along the claimed route marked A to B. It could be taken that the deposited railway plan suggests that a small portion of the route marked B to C may possibly be a public right-of-way. However, this still fails to clarify where the route starts and ends, if this is indeed the claimed route. The parish survey, which took place in 1954 upon creation of the first draft definitive map and statement, and the parish survey cards produced as a result of the survey, indicate that a public route existed along the line of the claimed route at the time of the survey. However, objections were made to the inclusion of these routes to the definitive map and statement at that time. The Staffordshire County Council records indicate that this designation was objected to. Subsequent counter-objections regarding these omissions failed, and as a result, the routes were omitted from the definitive map and statement. No evidence has been submitted or discovered to the contrary, and therefore the legal presumption of regularity applies, and it should be assumed that the Parish Council received and adhered to the detailed guidance and procedures set out in respect of objections and counter-objections. This application is made under section 53(3)(ci) of the Wildlife and Countryside Act 1981. There is a two-stage test, one of which must be satisfied before a modification order can be made. All of the evidence must be evaluated and weighed and a conclusion reached whether the alleged right subsists on the balance of probabilities or is reasonably alleged to subsist. For the first test to be satisfied, it will be necessary to show that on the balance of probabilities, the right-of-way exists. For the second test to be satisfied, the question is whether a reasonable person could reasonably allege that a right-of-way exists, having considered all the relevant evidence. In conclusion, without further supporting evidence, we cannot conclude that a public footpath is reasonably alleged to exist along the claim route marked A to B and B to C on the plan attached at Appendix B, and therefore officers recommend that the application is rejected and no order be made to add the claimed route to the definitive map and statement for public rights of way. Thank you. I'm happy to take any questions.
Any comments? Do we have any proposal?
Yeah, I'll propose to accept this as officer's recommendation.
Fine. It's been proposed. You are able to second, having declared an interest, are you? If not, presumably I can second it from the chair.
Yeah.
Fine. Okay. It's been proposed and seconded. Are we in favour? That's carried. Thank you very much. Thank you for your report.
Thank you, David. I think we've handled that as it should be handled. I understand that there are no issues for exclusion of the public on item 9. So that's the end of the meeting. Thank you very much for the officers for the time and reports, and thank you to members for coming along and listening to those reports and making decisions. Thank you very much.